I'm Vinnie Politan. The subject of my investigation, the brutal murders of 4 innocent college students. For some unknown reason, those 4 were chosen as victims, chosen by a cold-blooded killer. Here's the story. Ethan, Xana, Maddie, and Kaylee were 4 friends living together in an off-campus house at the University of Idaho. They worked hard and were all flourishing as students and having the times of their lives. They were popular, and their house was actually known as a gathering spot for fellow students. All of that tragically ended in the early morning hours of November 13th, 2022. Those 4 students were stabbed to death inside their home. The brutal crime shook the community and touched the nation. It set off an intense manhunt for a killer. Students were afraid to be alone on campus, and some of them never came back. Investigators from the Moscow Police Department joined forces with the Idaho State Police and the FBI. They followed every lead, every tip, and every piece of evidence. That investigation took them across the country to Pennsylvania and led them to this man, a grad student at a neighboring university in Pullman, Washington. This accused mass killer has denied all the allegations and claims to have an alibi. That last line, claims to have an alibi. Some big developments as to that alibi. Take a look at this. This is a motion filed by prosecutors, by the state of Idaho, by and through the Latah County prosecuting attorney, respectfully moves the court in limine for an order prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Yeah, they're not buying the alibi. And they don't want the defendant to be able to present that alibi through all these other witnesses. And that brings us to the first question in our investigation. What is the suspect's alibi? Right? That's important. What's his alibi? Got to figure out what it is before you can figure out how they can potentially prove it. Joining us, Court TV field reporter Cody Thomas and former homicide detective, host of The Interview Room with Chris McDonough. It is, of course, Chris McDonough. I want to do this, guys. Before we get into it, I want to sort of lay a little bit of the foundation of some of the things we know about this alleged alibi. Let's take a look. The alibi for the accused Idaho student's killer is that while 4 college students were murdered in the early morning hours, he was out for an innocent joyride. Defense attorneys call their client an avid runner and hiker, claiming he often took drives in the countryside late at night and in the early morning hours to enjoy the moon and stars. The accused killer's filing says that once school started, his hiking decreased and his drives increased. His attorneys plan to present cell phone data and photos of the night sky that show he was in the countryside on several occasions. The defense says their client's cell phone was south of Pullman, Washington, and west of Moscow, Idaho on November 13th, 2022. So they say the car captured on video along the Moscow-Pullman highway near Floyd's cannabis shop could not be his. Floyd's cannabis shop is off State Route 270, the main route into Moscow from Pullman, Washington. His alibi does not confirm or deny that other surveillance videos of the white Elantra in Moscow is him. All right, Chris, what are your thoughts when it comes to this alleged alibi? You know, there's more than one way to look at a case, look at the evidence, and I think you have to evaluate the evidence of this so-called alibi.
Yeah, absolutely, Vinny, and I think that's what the prosecution is asking for here. If he's going to present this type of evidence that, he was someplace else, he didn't have the means to accomplish the murders or anything like that, and the allegations are that he could have, well, then what they're asking for in this motion is, well, great, give us the investigative tools to verify all the things that he's saying. And that's what's sitting in the court right now in the judge's chambers to make that decision.
And what are your thoughts, Chris, about what type of evidence, other than him, could be used to prove this alibi? If it was, like, if someone is normally not at the scene of the crime, I mean, how can they prove where they are if you're by yourself?
Yeah. Well, that's a great question, Vinny, and I think the most compelling evidence could be some of the phone evidence, a digital footprint of some sort. However, if the defense is going to present photographs of night sky and that kind of stuff, remember, all of those photographs also have a stamp on the back, or, through digital technology, you're going to know exactly when that photo was taken.
Okay, Cody, we know you were on the case and out in Idaho, and you were at the park where this alibi is. What did you find?
Well, that's exactly right, Vinny. And one thing to note about this entire area of Pullman, Moscow, where the park is, where he says his alibi was at, is that it's all in relative close proximity. Well, Wye County Park was only about 30 minutes, 27-ish minutes from the apartment where he lived on Washington State's campus in Pullman, and about 40 minutes from Moscow. Now, one thing about this drive, it was probably, of course, I went out there at night to get the full feel of what his alibi would have been with the stargazing and all of that. It was probably one of the darkest, most unpopulated drives I've ever taken. I mean, there was no street lights, there were no street cameras that I could see. And to get down to where the actual gate of the park was, it took about 7 miles of gravel dirt road off the main road to go down, weaving into the valley near the river where the park is. But one thing about the park that I noticed once I got there was the gate was closed. That's a crucial piece of information that goes along with his alibi. Take a look at me when I was down at the park. He says during the window of time that the murders occurred, he was out driving around simply stargazing, specifically ending up right here at what he calls one of his favorite parks in his alibi, Wye County Park. Now, of course, there's nothing wrong with coming to a public park, doing what you want to do, stargazing included. That's what they're here for people's leisure in the community. But one caveat about this park in particular, it closes once the sun goes down and doesn't reopen until 7 a.m. And if you pan over here to the left, it's gated, and that gate is closed. No cars coming in, no cars coming out. So according to Bryan Kohberger's alibi, he says he was here during the window of time that the murders occurred. Now, we know those murders occurred between 3 a.m. and 5 a.m. Now, how is it that he could be out here at those times if this park is closed? Not to say his alibi is untruthful, but it does get a little muddy once you throw that crucial piece of information in here about Wye County Park. Now, of course, Vinny, that does throw a wrench into his story. The gate is closed, the park closes at sundown. And of course, there's regional things. People out in Idaho, it's a mountain town, lots of nature. When you grow up, there's parks nearby. You might know the ins and outs, how you could sneak in and go stargaze or do whatever you want to do. But again, just based on the facts that we know, that definitely throws a wrench in his story.
It's also a bizarre time. And I think, Chris, another important factor here for this alleged stargazing trip would be the weather. My understanding was that the weather was not great. It wasn't really a stargazing night. They may have evidence to the contrary, but I think that's a big piece of it, and being able to actually get into the park, probably an important piece of this.
Yeah, absolutely. And Cody's report is outstanding. He's not only going to be up against that, but there's a technology called Gladiator that the CAS team that the FBI use, and if they're going to just rely on just digital footprint like the phone, they're going to be coming up against this software that you'll hear about, I'm sure of it, in testimony in trial.
Yeah, and I think another important factor here is going to be his phone evidence. And our understanding is that the phone is turned off at a certain time. If you're going stargazing and you're taking pictures, you got GPS and everything else, you're going to need to have that phone on. So I don't know if there's another way, Chris, to explain a phone seemingly being off during hours. Could it be in some other mode if you're not hitting, maybe if you're not getting any cell signal?
The only other mode it could possibly be in is airplane, right? Airplane mode, right? Where it will shut off the signal, kicking out. But if he's taking photographs, again, that phone's lit. It's on. So he's going to have to explain that that problem.
Cody, did you notice your cell signal when you got around there? Was that a problem for you? Obviously, you may not have the same carrier, but how about your experience there?
Benny, I was just thinking about it as you said it, because as I was, explaining going down that 7-mile-long gravel road, as I got closer and closer to the entrance, my phone signal dropped. And I'm just glad I was paying attention to the turns that I was making out there at night. So that is something that his defense can bring in as far as cell signal dropping and picking up on the cell phone towers, but my phone cell signal definitely did drop when I was going deeper and deeper into the mountain valley near that entrance.
Okay, so when you're driving we just saw the highway there. Was that a problem for you, the highway? Because you're using you're not from there, right? Are you using GPS to get to the location?
Absolutely, I'm using GPS, and it wasn't a problem on the highway, and it wasn't a problem those first few miles once I turned off the main road. But as I got closer and closer, and I'm looking at the GPS read, 12 more minutes, 9 more minutes, 7 more minutes. Then I noticed on my phone, no signal at the top. So again, it was still showing me where to go, but if I were to refresh and try to start over, it was done. So luckily I was paying attention, but again, cell phone signal definitely did drop as I got closer to that front gate of that park.
Yeah, let me ask you one more question, Cody, about that trip. Was it a little creepy? Was it a little scary in the dark being in that area? Because you're by yourself, right? You're not with someone. I'd be freaking out, but this is his alibi is that he did this all the time.
Absolutely, Vinny. You might wonder why I took that video from inside the car at the beginning, at the entrance to that park. As you're going down this gravel road, there's field on both sides, cornfield or wheat or whatever it was. I didn't know what it was, but a big giant mass of field, acres upon acres, where you couldn't see anything. There's no cars going or coming. It's just me on this one road by myself. So, and that was around 9:30, 10 o'clock that night when I went. I can only imagine at some point between 3 a.m. and 5 a.m. out there by myself just for the sake of stargazing. So definitely a creepy vibe once I was going down that road.
Chris, 0 to 10, how plausible do you think, just the notion that in the middle of the night he's driving around by himself in a place where there's nobody else and he's just looking at stars?
I'm going to go with a 1 or 2. That's a plausible alibi.
Yeah, it doesn't make sense to me either. Cody Thomas, always great to have your tremendous reporting. The viewers demand it, and we're so glad you're with us. Chris is going to stick around. Coming up next, does he have to testify?
I'm confused because if the defendant's alibi is that he was out driving around that night, I'm not sure what additional information his cell data could add.
Grieving widow or mastermind behind a murder.
Monica Cimentelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cimentelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees?
The Celebrity Stylist Murder Trial, weekday mornings, only on Court TV.
I'm confused because if the defendant's alibi is that he was out driving around that night, I'm not sure what additional information his cell data could add to an actual alibi defense.
He says he has an alibi, the suspect, the defendant in the Idaho student murders. But take a look at this. I'm going to show this to you again. This is a significant motion being filed by the state. The state of Idaho, by and through the Latah County prosecuting attorney, respectfully moves the court in limine for an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination in support of any claimed alibi. Here's the big one. Other than from the defendant himself. Meaning the prosecutor's saying, listen, judge, if this guy is claiming an alibi and wants to argue alibi, he needs to get on the witness stand and tell the jury about his alibi and be cross-examined about it. That's what they want. Brings us to the next question in our investigation. Does he have to testify? And there's two ways to look at this question. We're going to try to answer both of them. One, legally, in order to argue that he has an alibi, does he have to testify under these circumstances? And then how about to actually convince one or more jurors that he wasn't there, does he have to testify? So 2 ways to look at this question. We're going to get the answers. So we've got some great attorneys with us. Joining us, the Idaho attorney who represented Chad Daybell, John Pryor, is with us, and trial lawyer, former prosecutor, and the former Idaho Attorney General. That's a big deal. Dave Leroy is with us as well. Great to have you both here. All right, John Pryor, legally, do you think that he has to testify in order to make this argument that I wasn't there, I was somewhere else?
Well, he doesn't have to testify, Vinny. I read the pleadings, and what I'm gathering from the pleadings simply is that it appears that his alibi wasn't specific. His alibi wasn't specific as to time, date, and place, at least for my perception. So at that point, the rule requires that his alibi gets stricken. And I think that's what the prosecutor is trying to do, is to strike his ability to use any evidence in support of that alibi. However, at the end of the rule, it says you cannot stop the defendant from testifying if he chooses to do so. So that's where I think this plays out.
Dave Leroy, what are your thoughts here about this non-specific alibi that they've sort of established here? Is this the way it's going to go, that in order for the defense to be able to argue that, he's going to have to get up on the witness stand and tell the jury where he was?
The defense last April suggested they wanted to tiptoe toward an alibi defense by calling a cell phone geolocation expert from Arizona who'd previously testified around the country to suggest that he was south and west of Pullman, as you have previously explored. It's my opinion that unless he does take the stand and set that testimony up, that the other defense experts who would be proffered to offer an alibi are going to not be allowed to testify by the judge. We have a 2021 Court of Appeals precedent that said that without specific details on these so-called alibi witnesses, that testimony can be stricken. So indeed, the defendant can always take the stand, but without his taking the stand, I don't believe there'll be any alibi evidence if the judge rules as I've suggested he's likely to rule.
Fascinating. Okay, so let's get to the other part of my question, the other way we look at this, which is, in order to convince one or more jurors, like, you're not going to be able to convince someone of an alibi if he doesn't actually get up there and say where he was, because it's not a case where he's driving with someone. The alibi is, I'm by myself. So, John, do you think that that's the only way, like in the real world, that a juror may believe his alibi is enough to be a reasonable doubt in all of this?
Well, I think Dave touched on it, and I might have a slight disagreement with Dave.
Go ahead, go at it. Go at it.
No, I'm not going to go at it with Dave. We've been friends. We've known each other a long time, so that's not going to happen. But I think there's a back way to get in the GPS evidence through the phone folks. But regardless, they're going to want to hear from him. They're going to want him to say, I was out, whatever I was doing, stargazing or driving down the 7-mile path to this park or something to sort of say, this truly was what was going on. Short of that, I don't think that's going to fly.
So, Dave Leroy, if he does take the stand to try to convince the jury that I wasn't there, there's some other things that may come up on cross-examination, like an explanation for how his DNA ended up on a knife sheath underneath the victims in all this. Now, the knife has never been found. There is no murder weapon in this case. Do you think that's enough to deter him from going forward with the alibi? Or do you think there's a chance that if they're saying he wasn't there, and maybe he wasn't there, I don't know, do you think there's a chance that he takes the stand here?
Well, I think there's always a chance. An article of personal property like a knife can suddenly go missing, can be stolen, can be misplaced, et cetera, et cetera. And remember, in terms of an alibi, his cell phone was not detected in the area of Moscow at the time of the crime. So in a sense, though a very weak argument. And he can say that his cell phone wasn't where they want to say he was and where the knife sheath is found. But Vinnie, you point out correctly that the best way for him to convince a jury of something related to the knife sheath, something related to this homicide, is to have a very compelling story of how he wasn't there, despite the fact the knife got there. It's fairly thin soup.
Yeah, John, that's the big piece of evidence, right? This is the foundation of the prosecution case, which is the DNA on the snap on the knife sheath. But I guess the best way to attempt to explain that is to have him testify about that knife sheath and what happened and where he lost it and when it got stolen.
Yeah, it's always risky for the defendant to testify, and Dave knows this as well, that that's usually not a very good idea. However, in this particular situation with the alibi and the knife, I think that's the only way he's going to convince the one or two jurors that he needs that he wasn't involved.
Okay, this is what we're going to do. Our two guests, I'm going to give you guys some time to cool off because I know you're going at it. Only kidding. But stick around because we need our legal minds as we continue this program. Up next, does the suspect have autism spectrum disorder? I'm Vinnie Politan. We continue our investigation of the murders of 4 University of Idaho students who were living their best lives. There is no apparent motive. It seems like it was just plain evil that took them away from their families and loved ones. Here's the story.
4 students were brutally murdered in their home near the University of Idaho. Kaylee, Maddie, Ethan, and Xana were great people with amazing futures that were taken away by a monster. The man accused of this horrific crime has denied doing it and has proclaimed his innocence. There is no eyewitness, no confession, and no direct evidence. It's a prosecution built on circumstantial evidence, which prosecutors believe is compelling, including DNA on a knife sheath found at the scene of the crime. The man who's been charged with this awful crime has a very unique background, living in Pennsylvania most of his life before crossing the country and heading west to study criminology.
Big, and this may be a very big development in the case. You know, here at Court TV, we keep our eyes on the court files because that's how you get a lot of the information in these cases. There are gag orders, there aren't press conferences. We're not in Florida, they're not releasing this information, the discovery, but the attorneys are litigating the case and they're filing motions. Take a look at this, because this is a motion filed by the defense. A motion to strike the death penalty. RE, Autism Spectrum Disorder. And then a motion to redact or seal newly filed records. So they don't want any of this made public. It's under seal right now. But going after the ability of the state of Idaho to seek the death penalty in this case, and it appears it is connected to autism spectrum disorder. So putting the pieces together here brings us to the next question in our investigation, which is, does the accused killer have autism spectrum disorder? And if so, I want to know what it is and what it means. Going to need some help for this one. Joining us, psychotherapist, author, host of Talking Live and the Bite Size podcast, Dr. Robbie Ludwig, and former homicide detective, host of The Interview Room with Chris McDonough. Chris McDonough is with us. Thank you both. Just before I start showing you some videos of the suspect, can you give us a little bit of a definition here, Dr. Robbie, about what autism spectrum disorder is?
So autism spectrum disorder is a developmental disability, and it impacts communication and social interactions. So often people with this disorder have difficulty with social interactions, making eye contact, communicating. It's very hard for them. And in some cases, they have very specific obsessions. They get very upset if their schedule is interfered with. They don't understand their own emotions very often, and it's hard for them to understand other people's emotions as well.
Thank you, Dr. Robbie. With that in mind, I want to show you this is a traffic stop that was done at Washington State University, October 14th, 2022. The suspect is in the car. There's this back and forth with the officer. Let's watch.
Hello, I am Officer Loangus. Stops being audio and video recorded. I think you know why I stopped you. You were in the red light.
What actually happened was I was stuck in the middle of the intersection.
Yeah,
so
I was behind you the whole time. Yeah.
Yeah.
So technically you're not supposed to enter the intersection at all for that reason, because if the light turns red, then you're stuck in the intersection, and then you're on the red light. So that's the reason I stopped you. Do you have your license on you?
Yep. So would you explain that to me a little bit further? So in Pennsylvania, when you're stuck like in their intersection, you have to make the left. So what would the appropriate thing for me to have done be? Just
You're not supposed to block an intersection like that in Washington, so just by you blocking the intersection, that's technically a ticketable violation, and then then you're running a red light, so it's another ticketable offense. So you're not supposed to proceed into the intersection until you can go, because a lot of people do what you just did, right? Is like you're sitting in the intersection waiting, and then turns, and then you're blocking, so.
Yeah, there was a little bit of confusion with speeding because someone had stopped. I wasn't sure what they were doing, and then they put on their light to turn. So I thought that maybe they were letting me go through.
Oh.
Did you see that?
No.
Yeah, like right before I made the turn, there was someone who like made a right. They didn't have their, their signal on, so I wasn't sure if they were just waiting.
Yeah, so I would just advise just don't enter the intersection until you can go, so you don't get stuck. Let's see.
But in that situation, the best thing to do then would be back up and not.
I don't know if there's a best thing to do in that situation, because you're either going to back up into somebody or you're going to run a red light. So, or you're going to be sitting in an intersection. There's not really a great option there.
Yeah, I was just slightly into the crosswalk, so. Where I'm from Pennsylvania, we actually don't have like crosswalks.
Oh,
so even if you're kind of slightly. There's a little bit more leeway as well. Like there are a few lines. Like there's one white line and there's another one. Like there's like a certain margin from which you can actually kind of put your vehicle, place your vehicle.
Yeah. So I know laws vary state to state, but there is a law in Washington for blocking an intersection like that, proceeding through when you don't. When you're just stalling. I forget the actual verbiage. I can find it for you, but it's like stalling, blocking an intersection.
Yeah, I'm just curious about the law. I don't mean to.
Oh no, yeah, I can find it for you. Yeah. 1 second.
Okay. Do you want to see one more first before we comment? Let's take a look at one more. One more. Now that was before the murders. This one is after the murders. He's presumed innocent, but this is after the murders when he's driving back home to Pennsylvania with his father, gets stopped, I believe, in Indiana.
He was right up on the back end of that van, pulled you over for tailgating. Is this your car? Okay, cool. Where are you headed?
Well, we're coming from WSU, and we're standing early.
What's WSU?
University, basically. Incident that was occurring with the shooting incident. That is SWAT team and everything.
So I'm having a hard time hearing you because of the traffic. So you're coming from Washington State University?
Yeah.
And you're going where?
Oh. We're going to be going to Pennsylvania.
Oh, okay.
Yep. So we're slightly punchy because we drive for hours.
Hours, days.
Hours to drive. Well, almost a day.
Okay. Let's bring everybody back in here. Oh. So, Dr. Robbie, are you seeing anything that would be consistent with autism spectrum disorder from his communications with law enforcement here?
Well, especially from the first interaction. I mean, usually when someone gets pulled over and they're, talking to a police officer about something that they did, they just basically say, I'm sorry, and it won't happen again. But we could see that Bryan got into this obsessional back and forth, like he was really trying to process and make sense of this interaction. It was challenging for him. We could also see too the odd interaction, the eye contact wasn't so great, the rocking back and forth. Definitely there was a disconnect there. And I actually had the idea that Bryan might be on the autistic spectrum. But again, this would have to be diagnosed by a psychologist who specializes in this or a psychiatrist. But I think we could see the oddity there, and it could indicate this disorder.
Yeah, Chris, another one of the oddities is he's in Indiana, driving from Washington State, which is far, far away, and the officer says, where are you going? To get some Thai food. Because if you want Thai food, you go to Indiana. Even if you're in Washington, you need to get to Indiana. What did you take away, Chris, when you watched this interaction? What do you take away from the suspect?
Well, I think the first thing, obviously to always understand is when you're making that type of contact on a busy freeway like that, the passenger seems to be answering a lot of the questions. So that kind of raises a red flag just for a second. But, what law enforcement is looking for, obviously, if this, allegedly, if he's involved in this incident and you're going to throw up a diminished capacity defense, then they're going to look for the type of foreknowledge, that he was putting into motion, i.e., was he doing things that he knew were proper? Was he making good judgment? And I think both of these traffic stops tell us that he was in complete control of his capacities and, in fact, wanted to engage the officers, and the first one into a debate about whether or not he had crossed that line at the stop sign.
Unbelievable, right? Dr. Robbie, New York Times did some reporting on his earlier life, right? When he was in Pennsylvania growing up. I want to read that to you. Let's put it up. The new revelations about the suspect come from posts he made on an online forum in which he discussed his mental health struggles. I feel like an organic sack of meat with no self-worth, he wrote in 2011 when he was 16, adding later in the same post, as I hug my family, I look into their faces, I see nothing. It's like I'm looking at a video game, but less. More that they wrote here. The words were posted on a forum website called Tapatalk, previously known as Youku, where the suspect commiserated with other users while suffering from a little understood neurological condition called visual snow, in which the person's vision is obscured by scattering dots, much like the static seen on an analog television. On the forum website, the suspect wrote that he saw a, quote, sickly, tired, useless, and stupid man when he looked at himself in the mirror and felt that he did not deserve to live. Nothing I do is enjoyable, he wrote. I am blank. I have no opinion. I have no emotion. I have nothing. Can you relate? He said his absence of emotion had begun about the same time as his visual snow symptoms in September of 2009, and one friend recalled him constantly talking about his fuzzy vision. Is there any connection here? What are you hearing as this younger defendant is describing what he's going through?
I don't know about the fuzzy vision, but I think what we're seeing here is that Bryan experienced a social disconnect. He did not feel connected to his family. And then we hear the other side. So autism spectrum can coexist with depression or anxiety. And what we're hearing is also the depression that Bryan was experiencing and the low self-worth. And it seemed like they worked together. The disconnect, depression, not knowing how to feel more connected. He was aware of his inability to kind of connect and feel like a real person. And, people with autism spectrum aren't necessarily dangerous, same with mental health issues, but somehow the two of these together in an undiagnosed way seem to put him in this vulnerable place and maybe make him more homicidal in some ways.
Dr. Robbie Ludwig, thank you so much. Chris McDonough, thank you as well. Appreciate it. When we come back, will his alleged disorder keep him off death row if convicted?
We are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that involves.
911 emergency.
Can you get someone over here now?
Well, okay, what does he look like?
He's O.J. Simpson. I think you know his record.
They were broken up, and he was still madly in love with her.
He didn't think that he was a batterer. I said, hey, man, you hit her. You're a batterer.
This is a murder case. They felt it had nothing to do with the murders.
Trial and Error. Why did O.J. win? A Court TV original series. New episodes Sunday night, 8 Eastern and Pacific. Only on Court TV.
If there was a conviction, and if there was a death sentence, and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your emotion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional. But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out.
The defense in this case is spending a lot of time trying to take the death penalty off the table. And it happens in almost all death penalty trials that we cover. A lot of pretrial litigation trying to eliminate the death penalty. In the case of Lori Vallow Daybell, she was successful because of some things that the prosecution did there. Here they're making a bunch of arguments, and one of them has to do with this alleged autism spectrum disorder. We believe, everything is sealed, but we believe that that's one of them. And it brings us to the next question in our investigation, which is, will his alleged disorder keep him off death row if convicted? Right? Obviously, if he's not convicted, not going to go to death row. But if he gets convicted, will this alleged disorder, autism spectrum disorder, keep him off of death row? And this question I'm looking at two ways also, because there's a motion that's been filed by the defense to strike the death penalty, and we believe this is the basis of it. That's one place. Or at the actual penalty phase of the trial, if convicted, could it be used as some sort of a mitigating factor that he suffers from autism spectrum disorder? So let's bring in our guests who are going to help us through all this. The Idaho attorney who represented Chad Daybell, John Pryor, is with us, and the trial attorney, former prosecutor and former Idaho Attorney General Dave Leroy is with us. One representing George Washington in the background. I see that, John. And I think I see Abe Lincoln behind you, Dave. That is awesome. Let me start here, Dave. Motion to strike the death penalty. If what they are filing, because it's under seal, is because he suffers from autism spectrum disorder, is that potentially a reason to have it taken off the table?
There's no basis to strike the death penalty in Idaho. When I was Idaho Attorney General in 1981, I successfully presented to the legislature, obtained the governor's signature on a law that eliminated the insanity defense in criminal cases in Idaho. We're now one of 4 states that do that. Our Idaho Supreme Court has held that to be constitutional. The United States Supreme Court refused to review it. Therefore, there's no basis to strike the death penalty at the trial level. Mental disease or defect is not automatically a defense. The prosecutor still must prove the mental elements of a crime, and first-degree murder, that would be premeditation. But nothing I perceive about autism is a basis to preclude automatically the ability to form an intent to premeditate. Back to the question. In terms of mental health, that can be presented at the penalty phase should there be a conviction. and should the jury be considering the death penalty in mitigation. But again, it does not automatically mean that the death penalty should be taken off of the table. It simply means that mitigation evidence in the nature of autism could be presented. And in terms of these horrific crimes, having a social inability to relate precisely or comfortably seems to be a very thin defense and utterly unlikely to do anything like take the death penalty off the table.
John, you look like you're chomping at the bit there. Go ahead.
No, and David hit it right on the head. The only thing I see with the trying to strike the death penalty is their defense, or Mr. Kohberger's defense counsel, is trying to preserve the issue for appeal. They want to bring this up, and as David accurately reflected, I don't think that's going to happen, but they're trying to preserve an appealable issue down the line should Mr. Kohberger get convicted. And again, David stated it earlier that it's a mitigation issue at the penalty phase, and that opens up a can of worms in my mind that brings the state in, bringing their own expert on this autism spectrum, and the defense bringing it on the autism spectrum. And I think David is absolutely correct. This is thin. This is very thin that they think that they're going to be able to use a behavioral issue to get Mr. Kohberger off the death penalty.
How do you think a jury will react to it, John? How do you think it'll be received if they believe that he has autism spectrum disorder?
Well, that's why you pick 12 jurors and you try to get a wide spectrum of opinions on this thing, because what they're trying to do is catch one of them to show some sympathy for Mr. Kohberger. Now, I think David addressed this earlier, that it's going to be very difficult to find anyone who's going to sympathize with the fact that 4 very young folks were brutally slaughtered in an apartment by this guy, and he has a behavioral issue, and that's why we should let him off the death penalty. This is a big mountain that these defense counsels are going to have to climb.
Yeah, Dave, what are your thoughts about, an Idaho jury? Looks like they're going to pick one out of Boise. How they would receive information like this, and whether there will be any sense of a sliver of sympathy to keep him from death row if they convict him?
Well, I think an Idaho jury will pay attention to all of the evidence in mitigation. These kinds of cases typically begin with a defense presentation of some kind of indignities that a young person has suffered in their youth, some kind of trauma that has left them physically impaired, some kind of events in life that have moved them in a negative way toward this dreadful crime that's happened. They'll listen, but whether there's any likelihood at all that this kind of material would be sufficiently compelling, I find very hard to believe.
Yeah, I think I agree with you. I think I agree. And I think it would be almost anywhere. John Pryor, Dave Leroy, thank you so much. Expect future calls from us. Okay. Every trial is about something. Even when there's overwhelming evidence pointing at the accused, there's always an issue. Here, if the judge allows all the evidence in, it'll be tough for the defense to raise a reasonable doubt because there may not be any. If that's the case, this case will be about one thing for the defense: keeping the accused off of death row. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.